what does the voetstoots clause mean when you buy or sell property? You will often see it, probably in every sale agreement, that the property is sold voetstoots. This means as is. What you see is what you get. So if you see cracks in the wall, or dirty carpets, or broken walls, these are called patent defects. Patent defects are defects that you can see, and it's up to the buyer to properly inspect the property thoroughly before making the offer to purchase, so as to familiarize himself with the visible defects. The voetstoots clause will protect the seller against those visible defects because the buyer has the onus to inspect the property and buy it as is. However, some defects are latent or hidden. This means that you cannot see them, such as if the swimming pool is leaking, you won't be able to see that it's leaking. So it's up to the seller to disclose those latent defects. Now, the seller has the onus to disclose latent defects of which he is aware. In a case, for example, where the roof trusses are rotten, but the seller didn't know and was not aware of it, he's not obliged to disclose it. He is obliged to disclose the defects of which he is aware. So if every 2 days he has to top up his swimming pool, he has to tell the buyer that there is a leak. Failure by the seller to disclose latent defects of which he was aware renders him liable for the repair of those defects. But the plaintiff, who is the buyer in this instance, has to prove that the seller was aware of those defects, which is sometimes very difficult to do. So when you buy property, the onus is on you. In Latin we say caveat emptor, beware the buyer, familiarize yourself, go again, bring your electrician, bring your plumber, bring your mother-in-law, bring whoever you want to bring, any expert, to inspect the property on your behalf before you buy. And good luck.